Desh Ratan Nigam is an advocate and RSS researcher. Joining us, Bilal Khan, lawyer and Muslim activist. Sumit Chander is also an advocate. And Sumit, let me begin with you. Because there was similar survey allowed in the Gyanvapi case, while all cases are a little bit different, fundamentally they are similar too. And because such a survey was allowed in the Gyanvapi case, even the Supreme Court went on to make that very massive observation in that case that determination of the character of a place of worship is not barred under the Places of Worship Act, and therefore there is no ground to stop such a survey. Did you feel that it was a given that such a survey would also have to be admitted in the Mathura case, and if they were to go to Supreme Court again, a survey will have to go ahead?
Let us understand why a survey needs to be conducted, or in what circumstances does the court allow a survey to be conducted, as in this case. Order 26, Rule 9 CPC is what talks about appointment of the commissioner to make local investigation. Now, the judge is not expected to go and physically examine a certain place, so he appoints a local commissioner.
Sure.
So wherever he deems fit that a local investigation is requisite or proper for the purpose of elucidating any matter in dispute, it is in these circumstances the court may issue a commission to such person and ask them to do the investigation and file a report. Of course, when a report is filed, so there is nothing that is deciding the case at this stage.
Sure.
It is only for appointment of a local commissioner to go investigate and file his report.
The reason I asked you this question, and let me go to Bilal Khan also. The reason I asked this question is because the contention of the mosque sides have been that, listen, there is the Places of Worship Act and you cannot be indulging in this action because fundamentally this is to change the nature of the place of worship as it stands today or post August 15, 1947. But the courts have in the past argued that just ascertaining the facts is not the problem. Even if it raises questions over what the final outcome will be, nothing can stop or should not stop. Even the Places of Worship Act, which is under challenge itself, should not stop fact finding, which the Muslim side has been opposing.
Muslim side said again and again, what about the Places of Worship Act? And the situation is not right now is this कि जो भी चीजें हैं उसको अकॉर्डिंग टू द लॉ वो बिल्कुल जिस तरीके से ज्ञानवापी के अंदर सर्वे की बात की गई, बट ये सर्वे का डिसीजन है, नॉट इन अ फाइनल डिसीजन, सर्वे डिसीजन।
जी बिल्कुल, बट सर्वे डिसीजन को भी मुस्लिम जो पार्टीज हैं, चाहे ज्ञानवापी का केस हो या मथुरा का केस हो, उसमें अपोज करती रही।
एंड देन ही मूव टू इन सुप्रीम कोर्ट आल्सो, मे बी ही इज गॉन।
तो आप क्या मानते हैं कि सर्वे करना जरूरी नहीं है, क्योंकि ये बहुत ही सालों से, बहुत सेंचुरी से ये डिस्प्यूट चल रहे हैं, तो कुछ तो फाइनलिटी करनी पड़ेगी ना इसकी, तो उसके लिए एक फैक्ट फाइंडिंग मिशन तो चाहिए ही।
देखिए, स्टार्टिंग से क्वेश्चन अगेन एंड अगेन, जब पार्लियामेंट से एक चीज पास हुई है, कानून पास हुआ, प्लेसेस ऑफ वर्शिप एक्ट है, उसकी धज्जी उड़ाने का काम जब कहा गया था, जब बाबरी मस्जिद का जजमेंट आया था, उसके अंदर ये कहा था, सुप्रीम कोर्ट ने डायरेक्टली कहा था कि उसके बाद हम लोग जो है इसमें मथुरा वाला और काशी वाले में इन्वॉल्व नहीं करेंगे, इसको प्लेसेस ऑफ वर्शिप एक्ट इस पे रहेगा, बट इसमें नहीं रहेगा जो हमारा बाबरी मस्जिद का जजमेंट। उसके बावजूद भी फिर ये लोग यही दोबारा कर रहे हैं। बट ठीक है, ये पीआईएल
डाल के देखो लोग क्या कर रहे हैं बिलाल जी, वो तो एक चीज है, लेकिन कोर्ट अगर अलाउ कर रहा है तो उसके पीछे लीगल ज्यूरिस्प्रूडेंस होगी, ये भी आपको मानना पड़ेगा।
कोर्ट अलाउड कर रहा है, आई एग्री विद यू, कोर्ट के डिसीजन पे मुझे कोई भी संदेह नहीं है ना, एज एन एडवोकेट मैं कोर्ट पे कोई सवाल निशान नहीं करूंगा, बट माय क्वेश्चन इज दैट कि जो प्लेसेस ऑफ वर्शिप एक्ट की बात की गई थी उसको रखना है या नहीं रखना है, वो भी क्लियर करना पड़ेगा।
जी नो दैट्स अ गुड पॉइंट यू रेज, नो दैट्स अ गुड पॉइंट यू रेज, आप अच्छा सवाल उठा रहे हैं। मैं एक बार फिर से फॉर द बेनिफिट ऑफ आवर व्यूअर्स आई वांट टू से दैट इन May 2022 when this entire Gyanvapi case was being argued and a survey was being talked about, which was eventually ordered later in that year, the court had said, the bench led by Justice Chief Chandrachud had said that ascertainment of religious character is not barred under Section 3 of the 1991 Places of Worship Act. So the court has already opined on whether a survey is barred or not. On top of that, Desh Ratan Nigam, there are exemptions to the Places of Worship Act. They may be espoused in the Ram Janmabhoomi verdict or not, but that's the law. Any place which is ancient, historical and is part of the archaeological site covered by the ancient monuments and archaeological sites is not barred by the Places of Worship Act. A suit that has been finally settled or dispute of not barred under the Places of Worship Act. And in this case, I'm pointing this out particularly because in this case it applies, the Krishna Janmabhoomi case. Any dispute that has been settled by the parties or conversion of any place that took place by acquiescence before the act commenced. Now I'm mentioning this because in 1968 there was an agreement between two parties in this case where the land was divided. So that can come under question. The Places of Worship Act does not bar it.
Yes, absolutely. In your previous program, Shivani, I had mentioned Section 4 of Places of Worship Act 1991, and you are exactly reading that particular section. An exception, a proviso has been carved out that if it is under the Ancient Monuments Act and at the time of passing of that act, if it is more than 100 years old, then this act will not apply. And therefore, this exception has already been carved in it.
But what about the fact that Bilal Khan was raising that during the Ram Janmabhoomi verdict, it was said that this shall no longer apply to any other such historical sites that are under dispute?
No, here is the question of a title, whether the particular management committee, while entering into a compromise, did not even have the power to do that.
Yeah.
Because they were to manage it and they did not have the title. So that has been under challenge. So this, both under the exception and special circumstances of this particular case, the law is slightly different in this case. And as rightly pointed out by Sumit, under Order 26, facts and truth has to be ascertained through investigation. And that report would be open to challenge by either of the parties when it is submitted to the court.
Yeah.
And therefore,
Desh Ratan Nigam, beyond the legalities, I do want to ask you that, you know, a lot of these cases that are coming up after Ram Janmabhoomi, of course it is Gyanvapi and Mathura, there is a lot of consternation amongst the Muslim, at least a section of the Muslim population, that will feel to ek ke baad ek, you know, hota hi ja raha hai. We were told that this will not happen and now look what is happening, case after case. How do you address that concern?
See, Hindus only wanted 3 places, if you recall. If
But
the Muslim
3 major
side,
cases, but if you ask different parties, they will say there are more places as well. Let's not say that it's just 3.
No, 3 places in the initial, if you write from the beginning, the
Yeah, sure. The
sections of
movements
the
have been
people,
largely surrounding
for
these 3 places. Yes.
And if they had agreed, probably other places people would have said, fine, we'll give up. But the fact is, they did not agree. It is about truth versus untruth. The fact is, they know that most of these buildings where it has been destroyed and taken over and a mosque has been built, it is not a mosque under Islam. Everybody knows about it. But somehow they are shying away from accepting the truth. That is the whole problem. That is why surveys and investigations are being opposed. Whereas the manifest signs and signatures of the Hindu temples are spread all over the place.
Certainly in the case of Gyanvapi and Mathura, that is the case. So